maybe the best place to start, given that we are focusing on these new US state laws, is where we were in 2018, which probably for everyone in this room was actually in a sort of pre or post GDPR frenzy or recovery. But what was happening in the US was, for the first time, the introduction of this law, the California Consumer Privacy Act, regulating data in a sort of industry agnostic way. And what we'd had up until that point was this patchwork and combination, as Clay mentioned, of federal regulation, the FTC Act and Section 5 in the FTC kind of out there regulating privacy promises in privacy policies, and jumping in when companies had data breaches and sort of putting that under the umbrella of unfair and deceptive trade practices, and implementing and requiring companies to sign up to consent decrees. And then at the state level, so the so-called kind of mini UDAPs, the state regulators having a sort of similar regime but focused on privacy policies and notices and security incidents. And then, as Clay mentioned, a sort of sector-specific approach, covering healthcare data, financial services data collected about children online, and various other kind of areas that were deemed worthy of specific attention, but no real sort of omnibus privacy law. CCPA comes into effect, and by the way, there's a whole story that could take more than 45 minutes about how that law came to be in its form, but it came into effect far more quickly, I think, than anyone expected. And for the first time, we saw a law that was applying once a company was above a certain threshold in terms of collection of data or revenue generation, the law would apply regardless of sector, and impose obligations of stuff we all know from European privacy law, transparency, rights for individuals, some sort of new implications for security incidents, and so on. I think what was kind of a surprise around that was some of the very specific granular requirements, and we're going to be obviously comparing and contrasting this law and the new US state laws all the way through with GDPR. But one of the differences we saw straight away was, alongside some of these principles that we know and love, we saw some very specific prescriptive requirements. Add a do not sell link using those words onto your website if you are selling data, and so on. And now, fast forward a couple of years, we've had 4 other states introduce laws that are going to come into effect next year, which impose some of the same obligations as in California, but not all, and each of those don't impose the same obligations as each other, and hence the sort of comment about hurricane and maybe complication that we're now facing. Just to, I guess, finish up on this sort of introductory piece, it's starting to resemble a little bit like what we have in the US and breach notification state statutes, because there are now 50 of those across every single state, but they're very similar in some respects, but each of them is potentially slightly different. So I think that's the idea of that is certainly creating heartburn and headache for folks who are looking to now comply, and we're doing our best to support as best we can.